Horribly sorrowful testimony from the father of the young man who committed suicide in this case. The family is hurting. They're still hurting. They're never going to have Conrad Roy III back. And that's the bottom line in this case. Not surprisingly, the public reaction has been harsh. Cathy Russon, formerly of Court Chatter, currently of LawNewz.com, has her finger on the pulse of those who watch these trials closely. So, Cathy, welcome back. It's good to see you again.
Good to see you too, Aaron.
Okay, so look, I mean, I've been looking at Twitter while this was going on, while we were all on the air here together, and look, nobody seems to like Michelle Carter. I've seen one or two people say, well, I don't think a conviction should stick in this case because the person who actually killed himself is dead. Okay, and I wrote that piece on LawNewz.com to explain exactly how it happens legally, that explains the law that allowed the conviction to stick. But a lot of people wanted the max for this young woman.
Yeah, you know, really they were all over the board. What I saw, I'm watching our chat rooms that we have, and I'm on Twitter and Facebook. Absolutely, the dislike for Michelle Carter is high, like sky high. And look, how could anyone like her? I mean, outside of her family, if you're just looking into this case like we are, and read those text messages that she sent to him, she's not likable at all. Now, the viewers have been kind of all over the board. You know, some are like, throw the absolute max at her. Can't believe she did this. Did you read those text messages? She needs to be made an example of. Then there are some who are, right now, I'm actually reading in our chat room right this minute, that are arguing, look, she wasn't even physically there. Why? How can we blame her? And then that question comes up. Anybody that is bullying a child and that child ends up committing suicide, are they then convicted of involuntary manslaughter?
Well, I'd have to go through the
conversations that are being had right now.
I'd have to. Okay, so the answer to it is in the piece that I wrote for LawNewz.com, and I explain exactly how that works. You know, they import some duties from personal injury law into criminal law in this instance in Massachusetts, and they've done it for a long time there. This is pretty well settled in Massachusetts. I know we keep talking about this being a novel case because it's text messaging, but really that's the only novel part of it. This law has been pretty well settled in Massachusetts for a long time, and how they get there, I lay out in this piece. You know, they say, okay, well, and you have to look at it from a tort law standpoint of intervening and superseding causes. If, I do something that's going to land me in a personal injury accident and then somebody else does something, then in theory we both caused it. Okay, and just because if somebody does something that's a little bit worse or that results in a greater harm doesn't mean that I wouldn't also be culpable, and that's basically the standard. So, that's the way it works. And in other words, if the secondary act is foreseeable, then the person who set the chain of events in motion is also on the hook legally, okay? And the judge found, and correctly under the law, that because it was foreseeable that he would get back in that truck and die, that her needling him was part of the causation. She wasn't the total cause, but she was part of the cause. It's easier to read it than it is to discuss it. I suggest to people who are confused about that or stuck on it or maybe just don't like it are just going to have to read the piece. But I can understand that being part of the debate.
Yeah, well, yes, and I have tweeted out your article and put it in our chat room today because it's important that people understand everything surrounding this case. But I completely agree with the judge. Look, but for her, he had gone back out of the truck. Now, would he have committed suicide on another day? Maybe. Was he suicidal?
We don't know. We don't know, and that's the whole thing. So we've got to go with the facts that are on the hook. And Deborah, I'd like to bring you back into this because look, here's the bottom line. I think the one most critical thing that sunk her in this case wasn't the text message to the victim, wasn't any of those text messages. It was the text message to her friends where she basically memorialized what she said to him in the phone call. That's what really got her in trouble.
Right, absolutely, because he's deceased and we didn't hear from her mouth, or at least I'm not aware that we heard from her mouth what the phone call consisted of. Many people, my clients included, shoot themselves in their foot by putting things in text messages or emails or posting it online because she memorialized what happened. She said, I encouraged him to go back, I believe she said, I encouraged him to go back into the car. No one would have known that but for her text message, which the prosecutor was able to get into evidence.
Yeah, I've got the quote of it up on LawNewz. That's where this really stuck. And she admits the causation element of it coming out of her own words, even though, yes, he also played an element in it as well. She basically had, admitted, well, I was the impetus behind it, even though he committed the act. And so that's how it stuck. And it stuck not in a what if, but it stuck with a clear-cut record that the judge in this case could go back and look at and say, okay, that's the evidence that this actually went this way. And when you start to read all of the other involuntary manslaughter cases in Massachusetts to see how they determine these issues, this conviction was not really a surprise. I don't know, Cathy, we're talking about the reaction to it. I always take these things from this perspective and say, hey, look, if people are talking about this and reacting to it, the solution is to dig into the law. And part of the American experiment is that if we don't really like the operation of the law, we have a debate about the root of it. And then in the same breath, it disturbs me when people just want to spout off about the way it operates and complain about the outcome without looking at what causes that outcome.
Well, look, so I'm reporting from maybe the non-legal side of this, and what the public is seeing from the outside in looking into this case and their reaction from this. And you're right, if you don't like the laws, you need to be proactive and do something about it, or at least try to do something about it, or understand this case and understand what the judge needed to do or not needed to do. I think the majority of trial watchers were behind her conviction. She needed to be convicted. I don't think that that's a problem at all. Where the whole stand goes is on the level of time that she should be getting. And many think that she got off really, really light today, and they're not happy with that.
Well, the stay at the end of it was the real surprise. I mean, that was the surprise, and we heard some good analysis about that just a couple of minutes ago.
And the judge already had that prepared. Did you hear him say that?
Oh yeah. He was ready for it, But the surprise was that he granted it. Every judge knows, okay, well, this is part of the procedure. I'm going to listen to this thing. And then, okay, well, usually it's not granted. Usually the defendant's carted off to prison, and that's just the way it is.
I've rarely seen it be granted. And yeah, I've seen many applications for it, and I've spent thousands, hundreds of thousands of hours in court, and it's very rarely granted.
Yeah, and to see it granted in this case, this is a surprise. But maybe the reason the judge did it is because the judge knows that there's this novel issue of technology, and that might be the sticking point if a state court so finds, because I don't think the state court's going to rewrite the standard in this. The standard's been set in Massachusetts. I mean, they're citing cases in examining her case going back to the 1940s. So we're 60, 70 years in on precedent, and it's stuck time and time and time again what the elements of this charge involve. I don't think the appellate courts in Massachusetts are going to turn around and say, whoops, we need to back off. We can't keep going down this road. I think at a minimum they might say, well, she wasn't physically present for something, and but still the chance of that happening is minuscule in my mind, because I think the action here is going to be in federal court. That's where this might stick, because the Massachusetts courts have been holding on to these standards for a long time, and they've had a lot of chances to change them, and actually they tend to uphold convictions on these involuntary manslaughter counts. One of the cases involves people who knocked over a candle in a warehouse where I think they were squatting as tenants or something like that, and started a fire, and they tried to put it out. They couldn't. They walked away from it. Okay, the place eventually engulfs in all these flames from it. 6 firefighters die. That conviction on involuntary manslaughter stuck because they said, hey, look, you started the fire that they showed up to fight, and therefore you caused their deaths. You
Well, I
should
think
have called
argument-
911 to get him in when it was still a small fire. And that's how they do this in Massachusetts. These convictions stick, you know, but I hear what you're saying, Cathy. It's also an issue of the sentence. What is the proper punishment?
Right.
Now, that
Right.
one I'd have to do a little bit more research into, because the punishment aspect of this, the 2.5 years, that didn't surprise me. You know, I was thinking light sentence, possibility of just probation, but the stay, that's what gets me, the stay. You
And
know,
he was prepared. He was prepared to do that. So he must think, you know, I don't know, one of a couple things. One, what harm is it going to do to let her be out under, you know, supervision? She's not really a risk to run. She's not a risk to, you know, to do harm to other people. And she has all these restrictions. So he's probably thinking that. And the other thing is just this case is so unusual and so out of the norm. That he must have just been like, look, I don't know if she's ever going to really get time after an appeals court looks at this, so let's just, you know, let her out with some restrictions now. I also believe that the judge believes that she has some serious mental health problems, and that's where the core they need to concentrate on helping her.
yeah, I mean, and ultimately the judge correctly noted that that's the standard under this youthful offender law. So, Cathy, we're going to start switching gears here a little bit and head back to the Segura trial in a couple of seconds, but we always appreciate your perspective. We always appreciate the perspective of people in the chat rooms. I've been reading the comments on Twitter. I've been in the chat rooms. Really helps me understand the way people are reacting to things, and I try to answer everybody's questions as best I can. So we appreciate you keeping your finger on the pulse for us. So
People tuning in right now, they do need to stick around and catch this Henry Segura trial because it's fascinating and it just started today.
yes, this is a new trial for us, so we are standing by to go back there. And Deborah, just really quickly, final thoughts.